Good afternoon, everybody, and welcome to Reality Testing in London Arbitration. Does the system serve the needs of the users? Thank you all for making this lunch date with us. This session is the second of two seminars hosted by the London Shipping Law Centre as part of London International Shipping Week. Our first session yesterday on controlling time and costs in arbitration threw up a number of really interesting discussion points about the range of powers available to arbitrators and how best to make use of them, as well as the limits which de facto exist as to arbitral proactivity. Today, however, we turn our attention to the structures of arbitration and whether the balance is right. The backdrop to that discussion, of course, is that London Arbitration is a huge and very successful business. And as I said yesterday, we probably all share a degree of pride in our involvement in it. But it's very important we cannot sit on our laurels. Yesterday, we heard in discussion how other arbitral forums are being discussed and used by clients. London has no right to preeminence. It has reached that position only because those involved work so hard to make sure that the process works and that arbitration is as efficient and effective as it can be. And importantly, that where there are problems, those are identified and solutions found as soon as possible. So today we are asking those questions about the existing structures. Have we got them right? Are there problems? If there are problems, what are the solutions? I'll be handing over to the speakers in a moment, and I'm not going to do lengthy introductions because you will know them all by reputation anyway. You can find their biographies on the London Shipping Law Centre website, and we have a lot of ground to cover and limited time to do it in. I'll just give you the heads up. Topics up for discussion are, firstly, we've got a session on the choice of tribunals and consequences, diversity and other issues with Juliet. Vasanti will deal with Section 67 challenges and perceived problems arising from the Emirates case and multi-tiered clauses. Julia will deal with Halliburton and Chubb, whether it's an elegant solution or a poisoned chalice, and whether London maritime arbitration needs to be concerned about apparent bias. Karen will look at the review of the 25-year-old Arbitration Act, which is currently being undergone, and ask to what extent reform is necessary. And finally, Helen will give us an industry perspective on London maritime arbitration system. I should add, of course, that while Alika is not formally on the record today, nobody need be in any doubt that she, as chair of the London Shipping Law Centre, has been the driving force behind this seminar, as well as the one yesterday where she spoke. She's been instrumental both in the structuring and organisation of both. And she, and indeed many of yesterday's speakers, will be joining us for the full roundtable debate at the end. Now, a very short word about format. There's no need to take notes. There will be a recording of today and the papers will be published on the London Shipping Law Centre website. Every speaker is going to speak for about 7 minutes, and then each one will leave us with some questions or some thinking points to prompt later discussions. Do, however, please feed through your own questions in the Q&A section of the screen. I will try and pick those up and feed them into the topics for discussion at the end, unless there are any which are particularly suitable to online answering. Thank you very much. And I think it's now over to Juliet.
Thank you, everybody. I hope you have my slides on the screen. They should be coming any second perfectly. I'm honoured to be here to talk to you about some of the consequences of party selection of arbitrators. Moving to the next slide too. Parties' right to appoint their arbitrator is one of the most fundamental aspects of arbitration. But why? Why is it so important? Let's look at what a party wants. A party wants to win, obviously. And therefore, they want from their party-appointed arbitrator somebody who is going to maximise their chances of success. They want somebody who's going to understand and empathise with their case, buy into it. If they're an owner, they're going to want somebody who's worked for an owner or represented an owner. If there's a particular jurisdictional issue, they want somebody who knows that jurisdiction. But does the system actually work? Moving to slide 3. These are the issues that I'm going to consider with you in this very short time. A couple of overarching points. This is a very complex topic, and I don't have time to do it justice. It also means that I'm going to inevitably resort to generalizations and stereotypes, and I apologize for that in advance. So moving on, next slide, please. This, and I hesitate because this is actually somewhat offensive now, but it is still a relatively representative picture of the makeup of the tribunal. And I can see Sarah laughing, and I hope many of you are. It is changing, but this is still pretty common that we have a tribunal made up of men, white men of a certain age. And I'm not denigrating white male arbitrators of a certain age. I have sat predominantly with male arbitrators. They have, without exception, been brilliant, very professional, very organized. But is this representative of the industry that we're seeking to serve? Now, the gender makeup of tribunals is changing. In 2010, it was 6% women, 2017, 17%, and by 2020, the ICA study reports just over 21% women. But it's still very homogeneous in terms of ethnicity. And this is in many ways because of subconscious and affinity bias. We're biologically wired to prefer, trust, and feel comfortable with people that look like us. And of course, the majority of arbitrators are white male and of a certain age. But actually, does it work? Now, there are many different types of diversity. They're all on the slide here. The one actually I want to focus on is the bottom, cognitive diversity. So moving to the next slide. What relevance does diversity have to arbitration? As I said, it's changing in respect of gender diversity. We're also beginning to change in respect of ethnicity, but there are many other types, as I've shown. And does the current system reduce or perpetuate the risk of bias? Does diversity lead to improved decision-making? How can we judge that? And what is the intrinsic value of diversity? Can parties really believe that we'll get the best result from a tribunal that doesn't represent them? And is there a difference depending on which type of diversity we're talking about? Well, let's look at how a decision is made. Next slide, please. There are 3 stages: input, processes, and output. Inputs are the conditions that exist prior to the group activity. So that's your assumptions, subconscious biases that you bring. The process is how those inputs work together and are translated into the output. So how the arbitrators work during the hearing, deliberations, and the output, of course, is the award. Now, assumptions are formed by background experiences, cultural references, gender, age, ethnicity, a number of things. Let's look at an example now as to how assumptions actually impact on decision-making. Now, first, just want to say that the case I'm about to tell you is true, but it did not involve Cow and Gates. I couldn't find a picture of powdered milk that represented the party, so please don't think this is a Cow and Gate issue. But it involved an advertising campaign which was successful in most countries around the world for powdered baby milk. But it was not successful in the Middle East. And the campaign team couldn't work out why. They were all Anglo-Saxons. And it was only when somebody from the Middle East joined the team that they worked out what the problem was. For countries that read script right to left, what they were seeing was a happy baby drinking some powdered milk and becoming miserable, rather than what the campaign intended of a miserable baby being made happy by powdered milk. Now, this demonstrates 2 things. Firstly, the role played by assumptions in decision-making, and secondly, the risk of a non-diverse team. And like-minded teams give rise to functional bias with a limited or non-existent ability to see things differently. So in assumptions, if you think of it in international arbitration, we bring assumptions with us. How we view fact evidence depends on what our background is. How we view expert evidence, are experts a hired hand? What approach we take to disclosure and discovery, whether we go for a significant amount or nothing. These are all assumptions that we bring to the input and come into our process. Let's go on to another example. And this is looking at the benefits of diversity. So this is now slide 10, please. This was a Columbia Business School example, and it made up teams to work out a murder mystery. Each of the teams was given a huge amount of complex material, lists of suspects, witness statements, forensics, alibis, and they had to work out who had committed the murder. Some of the teams were diverse and some of them were homogeneous. And in summary, the cognitively diverse team, and cognitive diversity is where it relates to the manner in which people think and approach a decision-making process. And it exists, you have diversity where people approach the process from different perspectives and are willing to challenge each other and be challenged as to their prejudices and blind spots. So the cognitively diverse teams got the right answer 75% of the time. The homogeneous teams got the answer right only 54% of the time. And interestingly for us with sole arbitrators, individuals working on their own only got the right answer 44% of the time. One other interesting point is that the cognitively diverse teams, although they got the right answer, found the process far more challenging because, of course, they were challenging each other. So slide 11, I've talked through the process of actually, slide 12, Sam, the concern of whether a cognitively diverse team gets the right answer. But we have other concerns too in a non-diverse tribunal. We're missing out on great arbitrators. And with more conflict issues, which you're going to hear later today, we need a bigger pool of talented arbitrators. The impact on junior lawyers, we need to have role models. And particularly for those from minorities, they're not seeing somebody they can identify with and feel that they want to follow. So that gives a lack of opportunity for career progression. Also, you're going to hear, are we innovating and flexible enough? The lack of diversity does not lead to trying to innovate in the process that we offer as arbitrators. And that could impact on the future of London. So my questions for debate, going on to the final slide, should we strive for diversity? If so, why should we strive for diversity? Should we just because it's, quote, the right thing, or are there benefits to the parties? Is there any particular type of diversity we should prioritise? And if we should be encouraging diversity, how should we go about it? And are there any London-specific procedures that deter or promote a diversity? So 44 seconds over, I'm sorry, but thank you everybody for listening.
Thank you very much indeed, Juliet. And I have to say, I think you are bound to win the prize for the best slide as far as I'm concerned. Some really interesting and challenging ideas to come back to. And I think now I was probably wrong as to who's next. It's Julia next, isn't it, with Halliburton?
That's right. Thank you very much, Sarah. Let me just see if I can share my screen. Is that coming up? There we go. Well, good afternoon, everybody. And that was a very thought-provoking talk from Juliet. And in fact, it has some bearing on what I'm about to say. Now, you might feel that Halliburton and Chubb has been done to death in recent years, but it does seem to me that following the decision of the Supreme Court, it may be instructive to identify some of the problems which were thrown up by the case and consider whether the Supreme Court has solved those problems by its decision, or whether in fact the decision has simply created other potential problems. And then, having looked at that, to stand back and ask whether London arbitration, and especially maritime arbitration, is now in a stronger position than it was before as regards the rest of the world. Now, I'm not going to go into the facts of the case. They're set out in my accompanying paper, which is or will be available on the website. But you will recall that the case concerned the problem of an arbitrator who accepts multiple appointments in separate references arising out of the same facts, where there is one party who is common to both references. And that, of course, is relevant to the matters that Juliet has discussed about parties choosing arbitrators because they feel that they may derive some advantage from a particular arbitrator. Now, in that situation, the party who is only involved in one of the two references is quite likely to feel that the common party has an unfair advantage for two reasons. First, because it has an opportunity for interaction with the arbitrator in the second reference, from which the non-common party is, of course, wholly excluded. But there's also, secondly, the possibility that the arbitrator will be tainted by evidence or submissions which he hears in the other arbitration, about which, again, the non-common party will know nothing. And of course, you'll all be familiar with the increasing trend over recent years towards making allegations of apparent bias, often for tactical reasons rather than any genuine concerns about impartiality. And the acceptance of multiple appointments provides fertile ground for challenges of this nature, and indeed Halliburton made exactly such a challenge, broadly on two grounds. First, that the acceptance of multiple appointments in these circumstances in and of itself created an appearance of bias. Alternatively, even if that was wrong, the failure to disclose the second appointment created an appearance of bias. And as you will know, that the Halliburton failed on both grounds. Now, I'll start with the Court of Appeal decision. They endorsed the orthodox common law objective test for apparent bias. Up on the screen, would the fair-minded and informed observer, having considered the facts, conclude there was a real possibility that the tribunal was biased? Now, as regards disclosure, the Court of Appeal held that the arbitrator was under a duty to disclose, which arose as a matter of law. But disclosure was not limited to facts which actually amounted to apparent bias. For the purposes of disclosure, the test was wider, not whether the fair-minded observer would think there was a real possibility of bias, but whether he might so think. Now, it does seem to me, or it has always seemed to me, that there were four potential problems arising from this decision. First, related to the inequality of arms. Do these dual common law tests between them adequately address the very real differences between litigation and arbitration in terms of transparency? The Court of Appeal equated the two. They said that arbitrators, like judges, should be trusted to be impartial and independent, and so you needed something more than the mere acceptance of multiple appointments to create an appearance of bias. However, whereas litigation is open to everybody, everyone can see what cases a judge is involved in and how he decides them, arbitration is, of course, entirely confidential and takes place behind closed doors. English lawyers may be comfortable with the integrity of particular arbitrators, but why should foreign parties be required to take it on trust? So even if the arbitrator behaves impeccably, does the process itself create the impression of unfairness? Second problem is the potential disconnect with institutional rules. Like English law, the major institutional rules have a wider test for disclosure than for actual apparent bias. But unlike the English law test, which is objective, the institutions tend to couch it in subjective terms. Do the circumstances give rise to justifiable doubts in the eyes of the parties? Is this a material difference? Can these approaches be reconciled? Third problem was the lack of sanction. There was no obvious sanction for breach of the duty to disclose, so what's the point? If the facts do amount to apparent bias, the failure to disclose adds nothing and the arbitrator will be removed. But if the arbitrator correctly concludes that the circumstances don't in fact amount to apparent bias, then they clearly don't become biased simply by failing to disclose them. In practical terms, you'd need to find some form of dishonesty if a failure to disclose were to amount to bias in those circumstances, and how on earth do you set about proving that? But assuming there is no dishonesty, how do you sanction a failure to disclose circumstances which don't amount to apparent bias? And the fourth, and to my mind, the most interesting point, was the tension with the duty of confidentiality, what I've termed the catch-22. If it's alleged that the arbitrator is privy to inside information in reference 1, which is materially relevant to reference 2 because of an overlap of issues, etc., how can the arbitrator challenge that without breaching the confidence in reference 2? He has an unpalatable choice. He must either breach confidentiality in one reference, or if he doesn't want to do that, he has to resign. And there is, of course, endless scope for tactical challenge here. The Court of Appeal said the duty to disclose was paramount, and that the arbitrator must disclose even if he has to breach confidentiality to do so. The IBA guidelines say precisely the opposite. They say you should resign rather than breach confidentiality. So how do we square this particular circle? So we come on then very quickly to the Supreme Court. Now, they emphasised the primacy of an arbitrator's duty to be impartial and fair, whether that's a party-appointed arbitrator or a chair. They also upheld the traditional common law test for apparent bias and confirmed the wider test for disclosure applied by the Court of Appeal. But, and this is crucial, they said it shouldn't be applied in an inflexible one-size-fits-all manner. You need to take account of the particular context in which the question of bias arises. And so the differences between litigation and arbitration, for example, are very relevant. Lack of transparency and confidentiality of arbitration proceedings might call for greater extent of disclosure. But also, they said, you can take account of the difference between different types of arbitration. So, for example, in certain types of specialist arbitration, LMAA, GAFTA, ARIAS are obvious examples, there is typically a relatively small pool of arbitrators and the same people get appointed all the time. And these are also areas where it's not uncommon to have multiple arbitrations arising out of the same facts: string contracts, chains of charter parties, insurance claims against primary and excess layers where the arguments being made are the same up and down the line. In these fields, the Supreme Court said, the expectation is that you will have the same arbitrators sitting in multiple references because it ensures consistency and is more efficient. And they said in that situation, it's not caught by the duty of disclosure at all. In other words, if acceptance of multiple overlapping references is not regarded as objectionable in the particular field, there's no need to disclose them at all unless there's some other factor to take them out of the norm. They were unperturbed by the lack of any specific sanction. They said the ultimate sanction was removal, and even if the arbitrator wasn't removed, they might have to pay costs of an unsuccessful application if there was a breach of the duty to disclose. Importantly, they held that the duty of confidentiality is paramount and can only be overridden with the consent of the parties. But they held that that consent can be inferred as well as express, and that again depends to a large extent on practice and procedure in the particular field of arbitration. They said, for example, if you agree to arbitrate on the basis of a set of rules requiring the arbitrator to disclose certain information, you can infer the consent of both parties to that disclosure. And this obviously opens the door to the possibility that relatively anodyne, high-level information can be disclosed by the arbitrator without seeking express consent. However, if there was no if consent couldn't be inferred, it would need to be sought expressly, and if it was not forthcoming, the arbitrator would have to take a view whether he was required to disclose that information, and if he thought he was, but he couldn't get the consent, he would have to decline the appointment or resign. Now, the points I've suggested for discussion are: have these problems been satisfactorily addressed by the Supreme Court? Has the position of London maritime arbitration been strengthened? Does the system adequately serve the needs of the users? I've set out a few points you might want to consider in the hope of provoking some debate at the end. The advantages of the decision seem to me its flexibility and pragmatism. The contextual application of the fair-minded observer test brings English law closer to institutional rules, so that we now look through the spectacles of the parties, if not actually their eyes. And the notion of implied consent could be said to strike a sensible balance between the duties of disclosure and confidentiality. Paradoxically, seems to me the greatest weakness of the decision is also its greatest strength. It's the uncertainty. What is standard practice in a particular field? How do you assess it? How do you know when it changes? Discharge of the duty of disclosure requires an arbitrator to conduct reasonable inquiries. How far should these extend? And determining the scope of implied consent could call for a tricky exercise of judgment. And then finally, the imponderables. Well, we don't know how the decision will work out in practice because it's too soon. Have we seen the end of the tactical and opportunistic challenge? Can we now expect more precautionary disclosures? And if so, will we end up killing the goose that lays the golden egg? Because what I foresee here is that in areas where currently disclosure isn't expected, where an arbitrator accepts multiple references, if precautionary disclosures start to be made and become the norm, then that will change the practice and procedure, and the exception will no longer apply. So I leave you with those thoughts, and I hope for some interesting debate at the end. Thank you very much.
Thank you very much, Julia. I'm sure that will provoke some very interesting discussions at the end. And now, can I hand over to Vasanti, please?
Thank you. Well, greetings, everyone, and thank you, Julia and Juliet, for your very thought-provoking presentations. I'm going to cover briefly some important recent developments in relation to multi-tiered dispute resolution clauses in the arbitration context, and consider whether these developments serve the needs of maritime arbitration. Multi-tiered clauses are very frequently encountered in practice, particularly those which require parties to engage in friendly discussions or other ADR procedures before resorting to arbitration. Such clauses reflect what I believe to be the understandable aim of commercial parties only to resort to arbitration once they've tried and failed to resolve their disputes by other less confrontational means. However, what happens where one party alleges that there's been a failure by the other to comply with pre-arbitral ADR procedures, or where arbitration is commenced prematurely because of the need to prevent a limitation period expiring? Does premature commencement of arbitration without complying with those pre-arbitral procedures prevent the tribunal from having jurisdiction over the dispute? Further, does a finding by the tribunal on whether there has in fact been compliance with pre-commencement ADR process give rise to the ability of the disaffected party to challenge the jurisdiction of the tribunal? As we know, parties to an arbitration seated in England and Wales can apply to the court under Section 67 of our 96 Act to challenge an award of the tribunal on the grounds that the tribunal lacks substantive jurisdiction. Substantive jurisdiction is defined by Section 82 of the Act as referring to the matters in Section 30, subsection 1, subsections A to C, the text of which should be set out on the slide. I will draw attention in particular to subparagraph C that refers to what matters have been submitted to arbitration in accordance with the arbitration agreement. A challenge to the tribunal's substantive jurisdiction can be made as of right, and if successful, can result in the setting aside of the award. Now, one way in which English law has hitherto sought to avoid the practical conundrums posed by multi-tiered clauses is to refuse to enforce them on the grounds that they are uncertain or because they lack completeness, unless they comply with the three criteria set out in a case called Holloway and Chancery Mead. And I've set out on the slide what those three criteria are. If we go to the next slide, application of that test has led to the detailed multi-tiered clauses in Sulamerica in the Court of Appeal in 2012, and in Warr and Grant Thornton at first instance in the following year, being held too uncertain to be enforced as a matter of English law. In Sulamerica, the Court of Appeal had to consider whether an undertaking by parties that prior to a reference to arbitration, they will seek to have the dispute resolved amicably by mediation was an enforceable obligation. The clause also provided that if the dispute hasn't been resolved to the satisfaction of either party within 90 days of service of the notice initiating mediation, or if either party serves a notice terminating the mediation under the clause, then either party could refer the dispute to arbitration. The Court of Appeal held that clause to be too uncertain to be enforced, and Lord Justice Morbick said that he had no doubt the parties intended that clause to be enforceable, but because it didn't set out a defined mediation process or refer to the services of a specific mediation provider, the clause was not apt to create an enforceable obligation to commence or participate in mediation. A similar approach was taken to an equally detailed clause in Warr and Grant Thornton at first instance. Now, in Cable and Wireless and IBM, Mr. Justice Coleman had also expressed the view obiter in 2002 that an obligation to attempt in good faith to settle a dispute would be unenforceable because it lacked certainty and the court would have insufficient objective criteria to decide whether one or both parties were in breach. If we then go to the next slide, there was a marked sea change in the Emirates trading case in which Mr. Justice Tier had to consider enforceability of the following clause in a long-term agreement between the parties. And I draw your attention to clause 11.1, and the requirement that the parties shall first seek to resolve the dispute or claim by friendly discussion, and the words, if no solution can be arrived at between the parties for a continuous period of 4 weeks, then the non-defaulting party can invoke the arbitration clause and refer the dispute to arbitration. On an appeal under Section 67 of the Act from a refusal by the tribunal to treat the friendly discussions clause as enforceable, Mr. Justice Teare drew upon Australian and Singaporean appellate jurisprudence in upholding the friendly discussions clause as an enforceable condition precedent to the right to commence arbitration. And in doing so, he distinguished the decision of the House of Lords in Warford and Miles, which had been decided in 1992, in which Lord Ackner had stated that a bare agreement to negotiate lacked certainty and was unenforceable. However, the judge agreed with the arbitrators on the facts that the clause had been complied with. There had been friendly discussions lasting the prescribed period of time, and he accordingly dismissed the Section 67 appeal. However, it was common ground, it must be said, before both the experienced ICC tribunal in that case and Mr. Justice Teare, that if the clause was enforceable and if it had been breached, it did raise an issue going to the jurisdiction of the tribunal to hear the case, and could therefore give rise to an appeal as of right under Section 67. If we go to the next slide, the Emirates decision has attracted considerable attention, both in relation to whether friendly discussion clauses should be treated as enforceable under English law and what the remedy for breach should be, and whether a decision by arbitrators on the effect of such a clause and whether it's been complied with raises an issue which can be appealed under Section 67. Now, both of those issues directly impact upon whether the approach of English law serves the needs of the users of London maritime arbitration. Next slide, please. The first issue raises fairly and squarely the role of good faith in English law, in itself a huge topic, and whether as a matter of policy, good faith negotiation clauses should be upheld, and also raises the powers of the tribunal in the event of a failure to comply with relevant preconditions in a multi-tiered clause. In Emirates, the judge contemplated that damages might be awarded for loss of a chance. The second point highlights an important difference between jurisdiction and admissibility, and I think this is where the key development that has occurred this year lies. The distinction is highlighted by Mr. Justice Butcher in the Tatnef case in the following words. He says, issues of jurisdiction go to the existence or otherwise of a tribunal's power to judge the merits of a dispute. Issues of admissibility go to whether the tribunal will exercise that power in relation to the claim submitted to it. And a similar approach has been followed in the Singapore Court of Appeal as well. It had been common ground in Emirates that compliance with preconditions in a multi-tiered clause raised an issue of jurisdiction, and the contrary was not argued. Now, on the issue of whether compliance with pre-contractual requirements raises an issue of jurisdiction, which is reviewable by the court, as opposed to admissibility, where you can't appeal to the court, we now have the benefit of an important decision by Mr. Justice Burton, handed down earlier this year in Sierra Leone and SL Mining. Clause 6.9 of the relevant contract obliged the parties to first endeavour to reach an amicable settlement and then refer the dispute to arbitration in the event the parties shall be unable to reach an amicable settlement within a period of 3 months. One party decided not to wait the full 3 months and issued its request for arbitration early. The judge concluded that compliance with the pre-arbitral procedures in the clause raised an issue of admissibility and not jurisdiction under Section 30 of the Act, and accordingly, there was no possibility of an appeal under Section 67. Now, if this decision is followed, a plea based upon premature commencement of arbitration due to non-compliance with the time-limited negotiations clause would not give rise to a Section 67 appeal. So I'd now like to turn to the points for debate. Firstly, should the decision of Mr. Justice Burton be welcomed as limiting recourse to the courts under Section 67? And my own personal view on this is that the decision should be welcomed, provided arbitrators are prepared to use their existing powers to secure compliance with the requirements of the multi-tiered clause by, for example, staying the proceedings until there is compliance, or by applying cost sanctions against the party who has unreasonably failed to engage in discussions before commencing arbitration. The second point for debate is what approach should arbitrators take to enforceability of friendly discussion clauses. Now, my view is that tribunals should seek to give effect to them, because to do otherwise would be in effect to defeat the reasonable expectation of the contracting parties. However, the sanction for breach should be within the exclusive domain of the arbitrators and not reviewable by the court. And the third point which I'd like to raise for debate today is what powers do arbitrators have to secure compliance with preconditions in a multi-tiered clause, and what are the most effective tools in their armoury? I believe that tribunals can deem a claim inadmissible for non-compliance, stay the proceedings until there is compliance, and can apply cost sanctions in the event of non-compliance. There's also the prospect of tribunals awarding damages for loss of a chance, as contemplated by Mr. Justice Tier in Emirates. In my view, there are sufficient tools already in the box to enable maritime arbitrators to serve the needs of users, but I'd be grateful to hear all of your views later. Thank you.
Thank you very much, Vasanti. And you have managed to answer one of the questions which came in during the course of your talk, just at the end there. So well done. That takes one thing off our list for the end, but leaves plenty for discussion. Now I think it's over to Karen for her review of the Arbitration Act and what we should be putting on our shopping list.
Thank you. And thank you to the previous speakers for some very interesting presentations. Could we get, thank you, yes. 2021 is the 25th anniversary of the 96 Act, in case you needed anything to make you feel really old today. And I think the starting point is that most arbitrators and users of maritime arbitration probably would say that the Act is well bedded in and is working pretty well in practice. So why are we thinking about reform? Why would we tinker with something that's working? And isn't there a risk that we damage the delicate ecosystem that's evolved within the framework of the Act? If we could go to the next slide, please. The Law Commission's just completed a consultation on this topic, and it is clear that the aim is very much to maintain the global competitiveness of what we have to offer. And so with that in mind, I'm proposing two questions for debate. The first is whether we should embark on a review of the Act. And secondly, if so, what improvements might we think about making? So if we could go to the next slide, thank you. On the question of competition, we can get some quite interesting insights from the recent Queen Mary survey. And what we see is that for the first time, London and Singapore have tied as the most popular seat. Now, it's right to say that we have to approach these statistics with some caution because most of the respondents to that survey are not maritime arbitrators. But I think it would be a mistake to ignore these findings. And just thinking again about Singapore, and I've chosen Singapore simply because they're our nearest competitor. You know, there are other competing seats in addition. But we know that Singapore's been very active in a programme of constantly improving its arbitration legislation. And I've given some examples there on the slide of the sorts of things they've been looking at. There is also some evidence that the number of maritime arbitrations in Singapore, while it's still low, it is certainly on an upward trend. So London is in competition for business. And of course, competition can be a very good and positive thing if it prompts us to improve what we have on offer. So on my first question, I am in favour of review and some reform of the Act. And I'm now just going to spend a few minutes identifying some of the possible areas for improvement. So if we go to the next slide, the starting point really is, the starting point is to try to think about what parties value about particular arbitral seats. And again, we can get some useful pointers from the Queen Mary survey. Now, looking at that list, it's clear that these matters generally relate to stability and the support that's supplied by the legal infrastructure. And I think it's fair to say that this jurisdiction would tick all of these boxes. And so the starting point, to my mind, is that any reform should be an exercise in minor improvements or polishing rather than a root and branch reform. So if we just go to the next slide now, these are the areas that the Law Commission identified as meriting further thought. I think this is all fairly familiar territory, but I'll say a couple of words about some of them. The first is whether we should supply arbitrators with an express statutory power to give summary judgment or to strike out. Well, I mean, arbitrators probably already have that power under the Act. As we know, though, in practice, there is a natural reluctance to exercise it. And so the question is, by setting out specific provision for these matters, would we encourage a bolder approach? And indeed, is a bolder approach desirable at all? Moving to the procedure for challenging jurisdictional rulings, as we all know at present, any court challenge of the tribunal's ruling takes the form of a complete rehearing. So it is not an efficient procedure. And that raises the question of whether there might be a way of streamlining the procedure. Could you even require parties to opt for rulings either by the tribunal or by the court, but not both? I can see that there are some quite tricky conceptual issues that might arise from that sort of solution. But given the wastefulness of where we are now, it does at least merit, I think, some thought. Should we make appeals easier? Again, this is a bit of an old chestnut, and it's the idea that we need to ensure a steady flow of cases to the court so that commercial law can develop. And you can achieve that by relaxing the rules on appeals. You could also achieve it by relaxing Section 45, which gives the court power to make a preliminary ruling on a point of law. To my mind, this is not, I think, something that users of maritime arbitration are clamouring for, but I'd be interested to hear if anybody thinks otherwise. Should we update the provisions on service, give those a bit of a makeover to refer to modern communications methods? Yes, I think there's probably something to be said for that. And should we provide arbitrators with better remedies or tools for dealing with delay? Now, the parties to an arbitration are under a statutory duty to proceed expeditiously with the arbitration under Section 40. Slight issue is that there's no actual remedy for breach of Section 40. The arbitrators can make rulings or orders under Section 41. They can make peremptory orders. They could even dismiss a claim in cases of very serious delay. But these aren't the most nimble of remedies. So are there other tools that we could offer to arbitrators? And should we make interim orders enforceable in court, perhaps, and give them a bit of oomph that way? Moving on to the next slide. I'm just going to identify finally a few ways in which it seems to me the Act could at least be tidied up. The first is to amend Section 44 to ensure that it applies to third parties. And just very briefly, Section 44 is the provision that empowers the court to make freezing orders in support of arbitration. It's supposed to replicate the position in court proceedings. But unfortunately, the way the detailed provisions are worded has prevented the courts from offering this sort of support in the arbitration context. So that seems to me to be, in a sense, an easy win and something that we should give serious thought to. Moving to the next slide, some further thoughts about the Act and procedure under it. Should we try to make default appointments of sole arbitrators easier? For example, should we have a papers-only application procedure? Should we remove the inconsistency in the remedies that are available under the challenge provisions? It's not very clear why that inconsistency exists. It's been noted by the courts. So is that something we should have a look at? Turning to arbitration claims, and in particular now that witness statements aren't allowed to contain argument, should we revamp the procedure for Part 62 claims? Should we introduce statements of case, for example? Should we make greater use of paper-only applications? Should there be a procedure for the enforcement of interim orders? And then finally, just moving to the last but one slide, there are some acknowledged errors in the drafting of the Act, and there are some sections where the wording is not working quite as was intended. These have been worked through by the courts, but I think any review of the Act would provide an opportunity for the sort of tidying up of the legislative language in some of the provisions. So moving to the last slide then, I'm going to leave that there. I've thrown out a few sort of scattergun ideas. I'm very much looking forward to hearing other people's views when we get to the debate.
Thank you very much, Karen. Well, you've got a number of my favourites on your list already, and I think that will be very interesting to discuss later. But finally, we're going to come to Helen, who is going to give us the perspective of the industry on London maritime arbitration. Helen, thank you.
Thank you, Sarah. Good afternoon, everyone, and thank you for joining us. Now, as someone with over 22 years experience of shipping disputes, 18 of those with defence insurers where claims and arbitrations are handled in-house, or at least that's the intention, I think it's fair to say I've had a decent amount of experience with LMAA arbitration. I also canvassed the opinions of my club colleagues and got some quite interesting feedback on what they like and don't like about LMAA arbitration and what they think could be improved. So I'm going to do a quick overview of what we see as the pros and cons of LMAA arbitration, and at the end I'll pose a few questions for debate. So in a busy FD&D department, we see a lot of charter parties, and I personally get 2 or 3 new ones a week. I can confirm that the vast majority of them still include English law London arbitration provisions. Increasingly, many of them contain the standard clauses, such as the BIMCO dispute resolution clause. So London arbitration clearly still is the default forum for resolving shipping disputes, and long may that continue. I should emphasise, and this should still be the overriding sentiment after today's debate, that in our experience as users, the LMAA of LMA arbitration, it's positive, that nothing I'm going to say should change that or detract from that, even if my list of cons looks slightly longer than my pros list. Speaking of which, let's look at the pros list first. Yes, pros, not cons. I think it's fair to say that LMA arbitration is still the most user-friendly, accessible and reliable forum for maritime disputes, and it's what we use in the majority of the cases that we deal with very successfully. The quality of the service is mostly very high. LMA arbitrators are highly experienced and specialised in their fields, and they do provide the expertise needed for maritime disputes, which are very specialist by their nature. Of course, being able to choose your arbitrator depending on the type of case, technical, legal, etc., is a big plus, although, of course, this can turn into a con sometimes if it's abused for tactical reasons. Several of my colleagues commented that they have noticed an increase in proactivity from LMAA arbitrators recently in terms of case management. I can't say I've seen much of this personally. It must depend on the arbitrator, and I think more is needed. As mentioned by one of my fellow panelists yesterday, to its credit, the LMAA has shown it can be flexible and quick to respond to circumstances with its very fast publication of the guidelines for virtual hearings. The rules are updated regularly, with new versions coming out every 4 to 5 years, and improvements are made each time, which is great. and also the incorporation of certain elements of the CPR into LMAA procedure. A recent example being the guidelines on witness statements is also a very good thing, as it hopefully makes arbitration procedure more efficient. Although I note that the LMAA seems to shy away from the more draconian sanctions imposed by the court for non-compliance. Should the LMAA be stricter on these? That could be another question. So if we move on to the cons now. Next slide, please. So no real surprises here. The top two bugbears are still expense and delay. On costs, there is an issue in particular with medium-sized claims where it's very easy for costs to become disproportionate. Yes, we have the intermediate claims procedure. It's been around for some time now, but it doesn't really seem to have caught on for some reason. My colleagues and I have seldom used it. I'm a bit embarrassed to say, actually, I think I've never used it. I think part of the problem could be that until the latest version of the BIMCO dispute resolution clause, it wasn't even mentioned. Only the standard rules and small claims procedures. So part of the solution could be about educating parties to use the latest version of clauses in their charters. But yeah, believe me, it's not that easy to educate chartering brokers. In terms of delay, I'm talking about delays in publishing awards. I had one small claims case where it took the tribunal over a year to publish its award, and also in responding to applications and correspondence, whether urgent or not. And also, well, it's not all arbitrators actually, and some actually go to the other extreme, pushing the parties along and not allowing them any breathing space, which leads us on nicely to the fact that there can be quite a big difference in approach between arbitrators. For example, different arbitrators have a very different perception of what constitutes urgency. There's a big difference between arbitrators in terms of strictness when it comes to enforcing time limits, for example, or for sticking to the word limit in small claims proceedings, which can be very frustrating and leads clients to complain that it can be quite unfair. Another issue is the fact that you can get conflicting awards on similar cases and similar issues, and sometimes quite unexpected and surprising decisions, since arbitrators aren't obliged to follow precedent. I'm not sure what if any solution there is on this, by the way. Costs again, in terms of billing this time, some arbitrators still don't like it when you ask for a breakdown of their fees. Shouldn't this just be standard LMAA procedure by now? Now, the next one is a little bit controversial, and it goes to the discussion on bias. It seems that there is at least a perception that some arbitrators are too close to their appointing parties. This is quite worrying, because if trust in the LMAA and the arbitration process is lost, London Maritime Arbitration could be in real danger of losing its appeal as the go-to forum for shipping disputes, and we of course don't want that. But lastly, by conflict of interests, I mean where an arbitrator has another day job as a lawyer or expert or something else, maritime related, of course. Of course, I don't begrudge anyone the right to earn a decent living, but conflicts of interest, or just even the perception of them, are inevitable when an arbitrator is regularly wearing another hat. So, next slide, please. There's a lot there. Far too much for 7 minutes, actually. I see I'm there already. So here are my questions for debate. Should arbitrators take a more proactive role in case management? Should the LMAA take a more proactive role in appointments and constitution of tribunals? Should the LMAA take steps to ensure consistency in billing and costs? And what about diversity, the buzzword of our times? Juliet gave us a very insightful analysis earlier on the different types of diversity, but what I want to talk about is the male-female divide. And whilst this is an all-female panel, consciously so, I believe, thank you, Aleka, whilst I'm not a big believer in positive discrimination, let's face it, the LMAA is suffering from old boy club syndrome. If my research is correct, almost 30% of High Court judges are female these days, whilst only 11% of all members of the LMAA are. Isn't it about time that steps were taken to address this? So on that note, I hope I've given you some food for thought, fast food debate, also hopefully. I'd just like to reiterate what I said at the beginning about the fact that the LMAA does a fantastic job for the most part, and we, the users of LMAA arbitration, are very happy with it and consider ourselves very lucky to have it. Our intention is not to be critical or encourage the LMAA to change so much that it becomes a completely different animal, but to see if with a few tweaks, a good thing can be made even better. Thank you for listening.
Thank you very much, Helen. That was very thought-provoking, and I think it feeds in very well to exactly where I'd like us to go, because you finished off with the question of diversity and whether the LMAA should take a more proactive role in the appointments and constitution of tribunals. Those two can possibly go a little hand in hand. And I'd like to loop back to some of Juliet's questions. In particular, if we believe we should be encouraging diversity, how do we go about doing this? And I'd just like to see all of you, have you got anything you'd like to say on this? I shall ask Juliet first because it was her question originally.
Thank you, Sarah. Like Helen, I don't agree with positive discrimination, but I do believe in a lot of forceful nudging, shall we say. Part of that is acknowledging the problem, and that requires good data collection. And that's something I know the LMAA had been trying to do, but had been less successful than many of the other institutions in actually collating the data of arbitrators. I think we also need to understand, ultimately, counsel are going to do what is right for their parties. So you're not going to choose somebody just by virtue of them being diverse. We need to ensure, however, that the very wide pool of excellent women and non-white arbitrators is known. So we have to find a way of getting publicity out there as to who these people are. So there are things we can do, there are things we should do, but we should do it for the right reason, which is to get a better result, to get better decision making, rather than just because it would be right to ensure we give opportunities to everybody. I think we need to have the carrot as well as the stick.
Yeah, thank you. And the point has been made in the Q&A that if we manage to get a wider pool, that carries with it possibly a chance that there are fewer of the repeat appointments which lead to the apparent bias issues. Vasanti, you were volunteering to go next, I think.
In fact, I was just going to suggest that one practical way in which all of us who sit as co-arbitrators could promote diversity is to make sure that when we are making selections of chair or encouraging the parties to think about a chair, that we always include names of those who we know who do come from more diverse backgrounds that we respect. And that's been quite successful in my experience so far.
Yeah, that's a very good point. Yes, Karen, how about you, since you're in the middle of my screen at the moment?
Well, knowing what to do about it is the million-dollar question, but the thought that I was just pondering was that one of the key issues and problems with arbitration that we often talk about is the problem of delay and getting a hearing on and managing to find something that suits everybody's diaries. And I was just pondering on the fact that if you do have a wider pool of arbitrators, you would hope that those problems might recede somewhat because people will have fewer arbitrations to deal with and therefore more room in their diaries. But I'm going to pass on the question of what to do because I don't think I've got anything to add to the very good suggestions that have been made.
Yes, well, I'm going to invite Julia next, and then I'm sure that Alika is somewhere, and I'm sure that she will have something to offer on this. So Julia next. Julia?
Did you say Julia or Juliet?
I did, Julia.
Julia. Well, I think Vasanti is absolutely right. I think it will undoubtedly help if party-appointed arbitrators put forward proposals that include more diverse suggestions for chair, because I think part of the problem is simply that people in the absence of any information to the contrary, people default to what they know and are comfortable with. And it's really a question of getting the fabulous array of diverse and not necessarily traditional source potential arbitrators known and before people for selection. And I think the pledge has done a huge amount in that direction by encouraging firms to sign up to a pledge to appoint 50% women. I mean, it could be extended to other underrepresented sections as well. But I think once people have been introduced to the idea that there are all these other people that they may never even have considered as potential appointments, and once they see that they do at least as good a job as the more traditional and well-known arbitrators, then I think it will gradually cure itself.
Yeah. Alika.
Yeah. Hi, everybody. I got the impression from Juliet's talk that she talks about wider diversity, and this is an issue with LMAA. We're not talking about women only, but we're talking about other professions which are with other skills, not only legal. And there is a talk for many years now that we have to appoint brokers, make members of the LMAA, other types of professions which provide diversity in the disputes. We haven't succeeded that yet, but there is in some way there is diversity in that respect. But I found myself, now when you write an award, really, you need to have legal knowledge, and you have to have at least one member of the tribunal to be legally trained. Now, about women, we've done well with LMAA now. We have 5 women out of, I don't know how many we are, 45, 50. We need to do more, but it's not LMAA as such. LMAA says if you get appointments from the parties and you prove that you have a good market work, we consider you. So it is the part. I go back again to party autonomy. The parties have to consider women, talented women, to appoint them more. I noticed that they go away from the LMAA, some parties, and they appoint from chambers, they appoint from other places. They don't really stick to the LMAA members as such now. If they want to find a woman or any other profession, they can find them. So it's the party autonomy. And then we open the way for women or other professions to enlarge the list of skilled arbitrators.
Yeah, thank you. Philippa next, and then I'm going to come back to Juliet for a final word on diversity before we move on to another of the topics. Philippa.
I wonder whether there is a way of having some sort of list or even a training program for people who are interested in doing some arbitration, even if it's only a little bit on a part-time basis, as a lot of us at the bar do. I had a relatively recent experience with Juliet, in fact, where we were both party-appointed arbitrators, and we put forward somebody who we thought would be terrific as a chair. And that person was turned down on the basis of what was seen as a lack of relevant experience. I think sometimes one gets into a bit of a vicious circle because people like to think they're open to appointing a more diverse tribunal, but then in practice they cling to the names that they know. And I think that's often so, particularly with a chair, where the perception is that the chair is going to be running the show and needs to have an extra layer of experience. So it's difficult for people to get a foot in the door. I know lots of people from more diverse backgrounds who say, oh, I'd love to do a bit, but I'm not sure how to start. I think that's something that the LMAA could perhaps work on, having some sort of list or training program, as is done with mediations, where you can go and shadow for a bit. And that might help to break the deadlock a bit, I suspect.
And ensuring that everybody who's regularly practicing has got that list, so they've got those names in mind.
Absolutely.
Yes. Juliet.
Philippa has actually covered most of what I was going to say, which is fabulous, as has Julia with mention of the pledge. I just wanted to also raise, there is something called the African Promise, which is specifically involved in raising profiles of African arbitrators. One of the key things is this whole knowledge of who's out there, and what the pledge, which is the equal representation in arbitration for women, what that did was did a whole load of different speed dating for women shipping, maritime arbitrators, or for women in commodities or energy, construction, introducing the potential arbitrators to the council and to the clients. There's a corporate diversity initiative going on at the moment. So a lot of it is meaning we're not in the situation Philippa and I were in, where the councils say, but we've never heard of this person, or we don't know what their experience is or their ability. So I would really push for more knowledge of who all these people are. So thank you.
Yeah. And just before we sort of move away, because I do see it as a slightly linked point, Helen, when you were asking the question, should the LMAA take a more proactive role in appointment / constitution of tribunals, did you have in mind in part the question of diversity, and how did you think the LMAA might go about doing this?
Yeah, partly I had that in mind, but it's a bit difficult to reconcile that with not wanting positive discrimination. So, you know, I think there was a comment from one of the attendees asking whether a third arbitrator on a tribunal should be appointed by the president, and then assuming then that the president should appoint a woman or someone else who falls within the scope of whatever diverse profile we're trying to bring in. I'm not sure that's the answer. It's a tough one. I'm afraid I don't have any bright ideas on that. But I do think that sometimes it's a question of, as has already been said, knowing who's out there and wanting to have appointments. You know, it's hard to sort of, you know, find out really if somebody's really good who's out there that we would like to appoint.
Yeah, thank you. Philippa and Alika, you've both got your hands up. Philippa, is yours an old hand? No, it's a new hand. I can tell because you're waving a real hand.
Yeah, it's a new hand, but it's a quick one. And it's just to, I hope, answer Helen's point on positive discrimination. I think the appointment by the LMAA or by a chair in proactivity needn't comprise positive discrimination. Often it's a case of putting somebody really good out there who happens to be a woman or happens to be from a minority ethnic background, bearing in mind that one of the issues with underrepresented groups in all areas, and there's a lot of research to back this up, is that underrepresented groups in general tend to lack confidence. And I think you have a lot of people who are not from the usual pool who would be fabulous, but don't put themselves forward. And therefore, they don't need positive discrimination, but they need to be brought into the eye of those who are appointing rather more, who may well then think, oh yes, that person is terrific, they'd be really good.
Yeah, thank you.
Yeah. Well, the LMAA, to answer Elena's question, it doesn't have the remit of appointing arbitrators other than the small claim procedure. So the president is asked to appoint a sole arbitrator. Unless they change the rules, it's not in the remit of the LMAA. It's not an institution. So you would have to propose that to the LMAA to provide something in the rules. They can provide substitute. They appoint substitute arbitrators under the new paragraph 12 now of the new rules, but there's nothing else there.
Yeah, thank you. Okay, well, I'd actually like to move on to some of the questions that Julia raised next in relation to Halliburton. And really just now that everybody's had a chance to digest Halliburton and we've all heard what Julia has to say about it, what are the views? How is Halliburton coming out in the wash? And do you think it's going to be a good thing or a bad thing for London maritime arbitration? We've got a question come in as to whether specialist arbitrators would be discouraged by it from accepting multiple appointments. Julia, you are unmuted at the moment, so I'm going to get you to kick off since it's your specialist topic.
Well, this question neatly highlights my point about killing the goose that lays the golden egg. At the moment, the Supreme Court seems to recognise that in LMAA and GAFTA and ARIAS arbitrations, the expectations of the parties are that you will very often get the same arbitrator appointed in multiple overlapping references, even though there's only one common party. And that because everybody knows and expects that that will happen, and indeed to some extent wants that to happen because of the economies of cost and the need for consistency of decision, because those are the expectations, then this isn't something that which will of itself give rise to any appearance of bias, and so doesn't need to be disclosed. At the same time, the Supreme Court said that precautionary pre-appointment disclosure was nonetheless a good idea. So they were very supportive of the idea of precautionary pre-appointment disclosure. And you can see why, because the idea will be to head off any objection before it becomes a real thorn in the flesh. But of course, I think what is going to happen now is that it's not so much that specialist arbitrators are going to be discouraged from accepting multiple appointments, but before doing so, they will start to make precautionary disclosures. And of course, if everybody makes precautionary disclosures, that will, over time, become the expectation and the norm. And that will change the practice and procedure. And so LMAA, GAFTA, ARIAS will cease to be specialist areas where this is regarded as unobjectionable. On the contrary, they will become like every other area of arbitration, arbitrations where the expectation is that disclosure will be made. And so I think we do need to be, I think any self-congratulation on the part of the LMAA and GAFTA that they've sort of escaped the sledgehammer of disclosure might turn out to be premature. I mean, there are a number of ways that arbitrators could deal with this. I mean, they may start to include precautionary clauses in their terms and conditions about the fact that, that it might well be that they are going to accept other appointments in overlapping arbitrations. They might try to sort of deal with it preemptively. But it's going to be very interesting to see how this all plays out, I think.
Yeah. Yes, thank you. Karen, you were the first hand up of the team.
Yeah, I just wanted to make a couple of points, really. The first is, I mean, I feel the decision's introduced quite a bit of uncertainty in the sense that when you're presented with a potential appointment, a failure to disclose other appointments might be okay or it might not. I think the Supreme Court advert to this lack of clarity because they make the point that, this implied consent is based on custom. Custom always has to be proved by evidence, query the exact scope of the custom in question. And so I think inevitably my impression is that it's leading to many more disclosures than would previously have occurred because most of us will always err on the side of caution. I just wanted to make a more general point as well about the whole concept of consent and implied consent. And it just strikes me as slightly odd because the Supreme Court say that the duty to disclose is an aspect or an attribute of the Section 33 duty. And Section 33 is a mandatory provision and it can't be contracted out of. And if you look at the DAC report, they say that any agreement to contract out of mandatory provisions should be ineffective. And therefore, I think this particular angle wasn't really taken into account in the Supreme Court approach. And I do wonder how certain a basis the idea of implied consent is, or indeed any consent. The only other thing I would say is, as I read the Supreme Court judgments, there's a pretty strong steer that institutions, the LMAA aren't an institution, but associations like the LMAA should think very hard about amending their rules to introduce certainty on the disclosure that may or may not be required.
Yeah. Yes, Vasanti.
I mean, I would agree with the comments made by both Julia and Karen. I think that the Supreme Court decision perhaps doesn't focus sufficiently on the fact that there is always a need to be fair. And therefore, if you are in a position where, for example, you have decided a point in another arbitration in a previous way, which one party to the new appointment will know, but the other will not, you must be obliged, in my view, to disclose that. And I think if you bear in mind the overall requirement to behave fairly, precautionary disclosures are going to become much more normal, and that could in turn change what the practice is in relation to LMAA arbitrations.
Yeah. Alika.
Absolutely. And I agree, I happen to agree with all the previous commentators, so there's not much of a debate. The issue is actually, in my appointments, I think the parties now take the initiative, at least my appointments. They ask the question, can you act? Is there a conflict? And you have to answer that. In other cases, I do volunteer. I make the comment myself, disclosure in a way that I have no conflict and I'm okay. I think the parties will start asking these questions because of the uncertainty that's created by the Halliburton. And I cannot forget the experience I had in one case that one co-arbitrator was acting in, it was he had multiple appointments, and the non-common party was asking for a resignation, but the person was not resigning, and we had 6 months of stalemate. Nobody could move. The parties kept arguing, and it was a waste of money and time, and that should not happen. But the tribunal is powerless to do anything. Nobody can do anything. And some rules have to be invented, either the LMAA or a section in the Act, if it is reviewed, that somebody has to have control in this issue. If a party, for example, does not have enough evidence to go for Section 24 application, and is not certain he can prove justifiable doubts, something has to be done to progress the process of the arbitration. Eventually, that arbitrator with the appointed party agreed to step down, and we had a new arbitrator. But it's an example that should not happen again.
Yeah, thank you. Just coming back to Julia, who's put her hand up.
Yes, thank you. I just had one comment on something that Vasanti said about disclosing if you've decided a particular point in one way in the past. That's an interesting thought, but of course it doesn't entirely deal with the fact that each arbitration depends on the evidence and the facts in that particular arbitration. So the mere fact that you may have decided what superficially appears to be the same issue in one way on a previous occasion on particular facts and on the basis of particular submissions or a particular state of the law is no necessary guarantee that you would decide it the same way again. So I think that's really quite a difficult area, and it's one, as I say, it's a very interesting idea, but I think it's one we need to think about quite carefully. And the other point arose out of one of the Q&As, which was, could the problem in Halliburton have been that the court appeared to appoint the arbitrator over the wishes of one of the parties? Should there be a move towards appointing arbitrators that have no connection at all to any party? I think it's important to point out that there are two separate problems here. One is the question of repeat appointments. So where one party frequently appoints the same arbitrator in all its disputes. That is separate and different from the question that arose in Halliburton, which was specifically the acceptance of appointments in overlapping references. Now, the question of repeat appointments is frequently dealt with in institutional rules. You have to disclose if you've been appointed by a particular party or the same firm of solicitors more than X times in the previous 3 years or whatever it is. And in Halliburton, the arbitrator in question did disclose in advance that he had been repeatedly appointed by the common party in the past, and indeed was appointed by them in 2 ongoing references, and no objection was made to him on that score. So I think there are 2 separate problems that require to be dealt with in different ways. And the way that repeat appointments is currently dealt with is probably sufficient. We'll have to see how the overlapping references situation develops in the light of the Supreme Court decision.
Thank you. Well, I think I'd like to move us on by reference to one of Helen's points. Should arbitrators take a more proactive role in case management, which we discussed at quite some length yesterday, with, I think, broadly a view that yes, they should where they can. But crossing over with Vasanti's question 3, what powers do arbitrators have to secure compliance with preconditions in a multi-tiered dispute resolution clause in the event of non-compliance, and what are the most effective tools? Do we have any views about, what is the best way to deal with this kind of situation? Deeming the claim inadmissible, staying the proceedings, costs, sanctions, damages. Does anybody have any views on that question? Vasanti, I'm sure you do.
Yes, I think the damages route is a little difficult because it will involve assessing the loss of the chance that there may have been a settlement. I think a much more practical tool is staying the proceedings so as to allow the parties to go away and have their discussion for a particular period. And if it transpires that one party is simply in bad faith not engaging, then you've got cost sanctions, much in the same way as a court would have powers to sanction in costs if there has been a refusal to mediate, which is deemed to be unreasonable. So I think those powers are probably the most effective ones rather than the damages route.
Yeah, absolutely. Juliet, you've got your hand up.
Thank you. This is a really interesting question, and I think it's going to become more and more prevalent before tribunals and probably courts as well, with the number of multi-tiered dispute resolution clauses that are now put in contracts. One of the previous, there was a question in the chat from somebody saying, how should you draft these? I think to give the arbitrators the power to do what Vasanti is suggesting, and I agree with Vasanti, it's more likely to be a stay and police it rather than damages. But to be able to do that, you have to have a well-drafted clause that you can enforce. So you need to know exactly what the parties are intending, what are the time limits, what is the appointing institution if you're having mediation, really well set out. That then gives the tribunal the ability and the power to then enforce it by saying, right, your process, your multi-tiered dispute resolution clause should be taking, let's say, 3 months from start to finish. We are going to stay these for these 3 months, but we want to be able to then check what the parties have been done. I also actually would recommend that tribunals can be a little bit more aggressive in cost consequences if it becomes clear that a party has deliberately ignored the process that they've signed up to. But that may be overly aggressive for some listening.
Yeah, thank you. I've got no other volunteers to answer on that one. And there is one more thing that I do want to get in before we finish, which arises out of Karen's segment on the Arbitration Act 1996. Obviously, this is a hugely important review, and it's something that we all need to be thinking about and making sure that points that are important do get across. So I'd like to ask all the panelists, including yesterday's panelists who've joined us for today's segment, whether they would give me their view as to what, if anything, should be changed under the 1996 Act and why. Philippa has got her hand up. I shall take her first. Thank you.
Section 32 would be my choice. I would like to see the requirements of Section 32 relaxed to make it easier to go straight to court on a point of jurisdiction. So often parties have jurisdiction determined by the arbitrator, but they know they're going to end up in court anyway. And I think it would be good if it were just a bit easier to get there than under the current framework.
Yes. Well, it is an incredibly narrow window at the moment, isn't it?
It is, and arbitrators and parties are often encouraged to make more use of it. I think if the encouragement could be built into the statute, that would avoid some of the problems with Section 67 that Karen was referring to earlier, and the time and expense it takes to have a complete rehearing of a jurisdictional challenge.
Yes, thank you. Well, Vasanti is not muted, so I'm going to her next.
I think I would pick Section 67 and the right to a rehearing if there is a genuine jurisdiction challenge. I think there ought to be a restriction to running only those arguments that were put before the original tribunal. And I think there ought to be perhaps an extension of the waiver doctrine so as to ensure that even related points that were not argued before the tribunal are shut out on any appeal. This would, I think, ensure that parties brought their full argument to the table before the tribunal and that we don't have costly and lengthy Section 67 appeals.
And some of them are very costly indeed. I've been looking at the figures recently and we've got some running into the hundreds of thousands. Yes. Okay, thank you. Alika has got her hand up.
Well, it is a very controversial issue, the review of the Act. I think that it's been tried many times before. And I think about 20 years ago, when I was still at UCL, there was a move, I can't remember very well, there was a research done, a survey, and Lord Thomas wanted the result of that because he's in favor of Section 69 review. And I would be in favor of that if I could help it. Why I'm in favor of that? Because I like to have precedent. I like the law to develop more. And we have the arbitration awards. Some of them are published. We're not certain about the precedent in the awards, and we don't know whether the arbitrators follow any other precedent, actually. First is the judgments. Do they follow that? And we have to have new law, and is that will be good for the jurisdiction. Okay. It's not going to be bad.
Thank you. Juliet.
I would include a provision specifically entitling tribunals to make an order of summary judgment or a strikeout of part or all of a claim. I agree with Karen that there is there's clearly an ability to do that under a general arbitrator's discretion, but tribunals can be nervous of doing things if they don't see it actually in black and white in the Act permitting it. And I think that would really help in terms of improving the efficiency and therefore keeping the costs down of an arbitral process.
Thank you. Karen?
Well, I agree with Philippa about Section 32, and I'm also of the view that that might provide a way through the Section 67 problems. But I am going to say the amendment of Section 44, because I think freezing injunctions are a very significant advantage of arbitrating here. And it is incredibly frustrating that the wording of Section 44 has prevented the courts from giving effect to it in the way that was clearly intended. So to my mind, that is a very easy win and something that we should do.
Yes. Though, of course, it's not just freezing injunctions, is it? It goes wider than that.
Yeah.
Julia.
Well, I agree with that. I also agree with what Aleka said. I think Section 69, I think leave to appeal should be made slightly easier. Not very much, but slightly, because I think there is danger of the law ossifying in certain respects. Most demurrage decisions are still firmly anchored back in the 1970s. And I think we do need to ensure that there's sufficient supply of arbitration awards coming before the courts to ensure that the law continues to develop and keep abreast of the times.
Yeah, thank you. Now, Helen, Kathy and Ros, You are sitting there very quietly. Does anybody want to give us your view? Helen has unmuted. She goes first.
I think I'll say, purely from a practical and selfish point of view, to make my life easier, a review of the service provisions, bringing that up to date a bit, making it clear that service by email, etc., is proper service and all that. I think that would be appreciated.
Thanks, Kathy.
Well, as an aspiring arbitrator, I would be inclined to agree and to encourage some publications of some of the, albeit redacted, some of the awards that are made. And I think that's particularly relevant within the marine field, because so many decisions are made under arbitrations rather than going to the court. And we simply don't know the thinking that there is at the moment in deciding some of those awards.
Thank you. Ros, do you have a view?
I'm going to do what any good expert witness should do in my situation and acknowledge that this is not my area of expertise. Leave it with all of you much more qualified.
Thank you. Now, I'm not sure if Nicola is actually there or she's just haunting us. I think she's just haunting us. Okay, well, that is really... Oh, you are there.
I am here. I don't have any particular. I think the jurisdictional challenge would be useful, as with the service, just to make things very plain and clear for those of us who deal with these arbitrations day in, day out. Just on the nuts and bolts side at the beginning would also be useful.
Yeah,
to get that clarified.
Well, that's really interesting, because we've now got quite a spread of things where more than one of the panel would like to see a change. I think the reform of Section 44 wins by a short head, because I'm going to cast my vote there myself. But though Section 32 comes a close second for me, and we are out of time, so I'm just going to thank all of the panels for both days for really, really interesting thoughts and debates. It's been such a pleasure. And to Alika for thinking of it and getting us all organised and to the start line. And for everybody else who has helped to put it together, Gerard and Sam in particular. And thank you to London International Shipping Week for giving us these 2 slots, which has been so excellent and so interesting for us all, and we hope for you. Thank you everybody for joining us, and we hope to meet in person in not too long.
Thank you.
Thank you.
Thank you.
Thank you.